Hello, my name is Michael Shea, and I'm the Executive Director of St. Michael's Legal Center and an adjunct professor at the Cooley Law School. This program is being brought to you by St. Michael's Legal Center, which is a law firm, not-for-profit, Christian Catholic-oriented, pro bono, which means we don't charge for our services, academically connected to the Cooley Law School. We serve the poor and the working poor while also training new lawyers and paralegals. Today, we're going to be talking about package number 34, which can be found on the website of the Clerk of the Circuit Court for the 13th Judicial Circuit. This package is put together to provide you with all of the forms you will need to establish a paternity or to bring up any of the many issues that are involved in a paternity action. The package is to be used when there's never been a judicial finding as to the father of the child. So the package will address the paternity and the parental responsibilities, the parenting plan and time sharing, as well as custody, visitation of the child, and child support. If you are the mother biologically or the father biologically, this package is for your use. It can be used by either the father or the mother. Usually if the mother uses it, it's to try to establish the father as the parent responsible for paying child support. If it's used by the father, it's usually in an effort to state the responsibility for a child and establish visitation. The child must have resided in Florida for at least 6 months before you file the petition or the package, or in some cases when the child is still of young age, for instance under 6 months, that the child was born in the state of Florida. One of the parents must also live in Florida. The other one may be located somewhere else, like another state. The parenting requirements can be found in either English or Spanish in the package that I've just referred to, package number 34. I'm now going to suggest that this is a rather long video and that you should first take the form, find it on the website, stop this video, and print the form. The form comes with a lot of instructions. You should number the pages in the package. They are not numbered, as you will find when you print it out. We have a total of some 173 pages. As I said, this is a long presentation. As I'm going through this, if you don't completely understand something, stop, back up, and play it again. Because it is so long, you may want to pause at several places and take a break and then come back and play the remainder of the tape. Let's get started. On page number 3 is a list of all the forms that are covered in this package. I will be explaining all of these forms, but they are, the first one is going to be like rules that you need to sign saying that you will be civil in court. And there's going to be a cover sheet that you use when you file it with the clerk's office. Next, there's going to be the actual petition to establish the paternity, or who the father and mother are. Next, there's going to be a parenting plan. In some cases where there may be a problem with one or the other parent has a violent background, you may want to have a supervised safety parenting plan. We'll cover that. There's also a special type of parenting plan for long distance parenting, where one of the parents is located usually out of state. It could even be out of the country. We will next take up the financial affidavits that need to be filed. Next is the Uniform Child Support Jurisdiction Enforcement Affidavit. Then there is a series of forms for the child support and the amount to be paid. Next will be a pleading that notifies the court of the Social Security of the petitioner, mother or father, and the child. Next will be a summons to serve the other side, the other parent. And accompanying that will be a memo for the service of that person. Then we're going to have a certificate of compliance with mandatory disclosure. You're going to have to disclose to the other side, or in other words, each side to each other, financial information so that the child support can be calculated. We also are going to have to file a notice of related cases in case there's a domestic violence issue and a case has been filed in the past. Next, we'll want to file a non-military affidavit stating the person is not in the military. If they are entitled to special rights, and we'll cover those. Then there's a motion for default in case the other side doesn't answer. And there's an actual default that would be filed by the clerk, 2 separate pleadings. Then there's a motion for scientific testing to see if the parent alleged to be the father is actually the father. Next is going to be the fee schedule for the case. And finally, if you need to, you can file a notice that certain material is confidential and you want the court to recognize that. And then we're going to get into the requirement for notifying the court as to your address and email if you have it. And on a separate package, we will cover how to do electronic e-filing in Florida. You can either do it by entering the Florida court system, and we'll cover that in another video, or you can do it by email. I'm now going to switch over to page 4 and go through the steps that are necessary for you to take in filing a paternity action. The first step is to complete the forms that we're talking about today. The forms must be completed using black ink. You're going to have a cover sheet. You're going to file that you've read and agreed to the 12 rules to be conducted in court, and they deal with being polite. You're also going to then file the actual petition for paternity. Accompanied with it is going to be your parenting plan, your proposed parenting plan. You're also going to file your financial affidavit, your notice of Social Security number, your Uniform Child Custody Jurisdiction Enforcement Act, your child support guidelines, which is going to establish what you think the child support should be. You're going to file and ask the court to, the clerk's office, to authorize your summons. You're going to file your process service memorandum telling the sheriff where to go. And then you're going to file your designation of your address and email. That's step 1. That gets us into court with the proper forms filed. Next is you're going to want to make copies of everything. One copy for yourself, the original to be filed, and one copy to send to the other side. Step 3, you're going to go to the clerk of the circuit court in the county in which you live and file this package. Next, which is step 4, you're going to have to serve the other side. This means you're going to pay the sheriff or a private process server to serve those papers we just mentioned on the opposing party. If you're indigent, and for general purposes we consider a person whose income is less than $18,000, you may ask the clerk's office to certify you as an indigent. If you get certified as an indigent, you do not have to pay the filing fees, which are in Hillsborough County roughly $400, and you also do not have to pay the sheriff, which is about $40, to serve the papers. So if you think you're indigent, it is worth asking the court through the clerk's office to certify you. Step number 5, you must then obtain proof that the package you gave the sheriff or a process server has been served on the other side. Most county sheriff's offices automatically file a pleading with the clerk's office stating that they have served the person. That is not the case for out-of-state service. They usually send it back to you, and it is your responsibility to file it. Step number 6 is to receive an answer. If the other side answers, then they're going to be responsible to send you an answer. If they don't, in many cases people just don't answer, then after 20 days you're entitled to go to the clerk's office and ask them to file a default. Step number 7, you're going to comply with mandatory disclosure, and we'll cover that a little later in the video. You're going to disclose financial information to the other side. Then we get step number 8. You're going to have to attend a parenting class and produce for the clerk's office to file a certificate that you have complied and taken a parenting course. You can take these online, or you can take them usually at your local community college or other places that you can find on the web. Some are free, some have a minimal charge. Some courts require them to be taken in person. Most courts will accept the online course. Step number 9 is if there is a party on the other side, and it isn't a default, the court is going to order you to attend mediation and to see if you can come to an agreement. Usually the issues are child support and visitation. If you reach a settlement, then the case will be referred to the court with your settlement, and that should be approved, and that would be the end of the case. If you do not reach an agreement, we move to step 10, where you start preparing the evidence to put on your case. You're entitled to file interrogatories, which are questions to the other side, notices to produce papers and documents to the party on the other side, and third parties like hospitals and doctors and sheriff's offices and things. You're entitled to take depositions, and you're required to request production of documents. The discovery step, number 10, preparing for trial, is not covered in this video. You should probably consult an attorney if you have to do all of that. And then step number 11 is to go ahead and schedule your case for a final hearing. In between, the court may call you in for what we call case management conferences, or CMCs. Those will be sent to you by the clerk's office, and you are required to appear. That's where the court will send it to mediation, and in many cases also send the court case off to the magistrate, a junior judge or a helper judge that will help the court hear the case and then recommend to the court what to do. If you need assistance in Hillsborough County, there's a special department that deals with people who are pro se representing themselves, and it's called the Case Management Unit. Their telephone number is there on page 6. It's 813-727-5173. There are people at that number that can help you with the filing of the documents required. And they will review the court case and tell you if there's any necessary papers missing. They are not allowed to give legal advice, so don't ask them. Neither is the court. Then we move on to step 12, which is the actual final hearing. And while we'll talk about that in this video, it is beyond the scope of the video. I should also mention that on page 8 is a wonderful list of websites that can be used for this form, this package, and many others. Most of what we find in this package come from a website, www.floridacourts.org. That website contains hundreds of forms that have been written and approved for use by the Florida Supreme Court. All of the forms in here are from that website. They have been put together in package number 34 to be the required forms to conduct a paternity suit. But that's where they come from. So I refer you to that website and others found on page 8. On page 9 is what I have just told you in Spanish. And so I'm going to skip through the Spanish to the next applicable website form, and we're going to jump all the way over to page 20. And here we're going to talk about the instructions for general information in representing yourself. I should point out that in Hillsborough County and most of our surrounding counties, about 54 or more percentage of all the family law cases are not represented by attorney on either side. 78% of the family law cases only have an attorney on one side. That's a lot of people, and we hope that this video is helpful for you if you are trying to represent yourself. Next we go to page number 21, where we talk about notices regarding attorneys who are available to do help to you. They must be in good standing with the Florida Bar, and you can check with the Florida Bar website to see if they are. Family law procedure, I want to point out that it prohibits ex parte communication. Ex parte is a Latin word which means single or one party contacting the court and not the other. So a letter to the judge is not going to be read because it's an ex parte communication which is prohibitive. If you want the judge to read a letter, you must show on the letter that you have sent a copy, a CC, carbon copy, to the other side. Then it's going to be placed in the file and the judge may or may not read it. If you simply send a letter to the court, it will not be read. It will simply be put in the court file. And once again, we're just to remind you that to start this procedure, your actual petition that you're filing along with all these other documents is going to be what you actually start with. I'm now going to skip over to page number 24, and on this page we have a good section in the middle that is yellow, This is the beginning step that you should learn. We've covered this in other packages, but this is what we are going to refer to as the style of the case. So when I refer to the style, then this portion I'm talking about. On the second page, 225, is the ending of all your pleadings. That's also in yellow. So to go through this, it says in the circuit court of the, and you're going to put the number of the judicial circuit. In Hillsborough County, it's the 13th Judicial Circuit. In Pasco and Pinellas, next door to us, it's the 6th, and so on. Most counties in Florida are bunched together in groups of 3 or 4 counties and given a circuit number. That's what you need to find out. Bigger counties are a circuit by themselves. Tampa, Hillsborough, Jacksonville, Miami, Palm Beach, Fort Lauderdale, and so on are all circuits on their own. So number 1, you would put the 13th Judicial Circuit. In space number 2, you're going to put the county in which you're in. In my case, I'm sitting in Hillsborough County. Number 3 is the case number, and number 4 is a division. Those numbers will be placed on the pleading when you do your original filing. So, but when you take everything to the clerk's office to file, these will be blank. You can hand write in the case number as it's given to you by the clerk and the division number. Number 5 and 6 are for the petitioner and the respondent. Usually the petitioner is the mother who's asking for child support and assistance. If it's the father, he's bringing the action because the mother won't let him have access to the child, then he's the petitioner. It can be either. Whoever is filing this set of documents and pleadings puts their name as the petitioner, and the other party is the respondent. Now we go over to page number 25, and we are jumping to the end of the pleading. So in between is what we call the body of the motion or the petition, and it's going to tell the court the facts that you're basing your motion on and what you're asking for. And then we get to the part found there on page 25, which is calling for the date, your signature, your street address, telephone number, and so on, and a notary. So you're going to want to do that whenever the document calls for it. Next, I want to bring to your attention a glossary of terms which is found on page 27. This is a wonderful tool. If you don't understand a word, come back to the glossary here and look it up. I'll give you an example of one that I was faced with not too long ago when I was preparing for this, and that was contingent assets and contingent liability. Those are defined and explained in this glossary. So that's what this wonderful tool is for. Use it if you don't understand a word. We finally move on to page 33, where we have the 12 rules of courtroom civility. This is where everybody is made aware of how you're supposed to act in court. Paragraph number 1, make a truthful statement. It's against the law to make a false statement. Number 2, don't write the judge. We just talked about that, unless you copy the other side. Emails or letters or pleadings. Number 3, always be courteous. Number 4, treat the personnel of the court with respect. That's the bailiffs, clerks, and the judicial assistant, which is the secretary, as we used to call them, to the judge, and we kindly refer to them as the JA, judicial assistant. Don't make faces or frowns while in court and someone else is testifying. Make sure that you're properly attired when you appear in court. No jeans, t-shirts, sneakers, or flip-flops. Appear, usually we say, in business attire. Do not bring food or beverage into the court. Do not bring children to court hearings. Get a babysitter. Be aware that witnesses called should not be in the courtroom and should wait outside in the hall. Always bring 4 copies of anything you intend to use in your court proceeding. All documents should be pre-marked with your case number and division. And last but not least, be 15 minutes ahead of time for all your court appearances. Sometimes the court runs behind schedule, and that's their privilege. You are not allowed to be late, so be on time. And then there's a place for you to sign and submit this with your original filing. Next, we want to go over to page 36 with a form that's called Disclosure for Non-Lawyers. You will not need this form if you have a lawyer or if you prepare the forms yourself. But oftentimes people avail themselves of paralegals who are independent, not working for an attorney, and who offer their services to fill out forms like this. They know, and I caution you, that they are not allowed by law to give legal advice. But if you use one, then you have to have this form filled out disclosing who they are and what their name is. Next, we're going to cover on page 37 the cover sheet. Now, you're lucky because in this particular package, the cover sheet has been pre-checked. And so on page 40, we have a